Good morning, good morning, good morning. Very stupid o'clock, everyone. Welcome to another episode of Spilling Tea. I am your host, Tiffany Daniels, and we're going back to that dumpster fire of a place known as the JRC. But before we get going this morning, the usual disclaimers. First off, you are going to see the link to this investigative report done in 1995. Excuse me, I'm sorry, I'm sweating to death. Oh my god. Missouri, you're drunk, go home. Sorry about that. Missouri weather. One day it is cold as shit outside. Next day you like freaking frying in here. It's a freaking sauna. But the usual disclaimers. As I was saying, first off, you are going to find the link to this investigative report right there in the description box, alongside the other pertinent links to the Stop the Shocks campaign, including Autistic Hoya's massive archive on the subject, where we get the bulk of the material on this channel for the JRC. We also have the ever-present tin plates. Sign your name, click on your senator. Takes less than 2 minutes and you could save a life. We are trying to end improper restraints, adversive therapies, and seclusion in schools. It kills kids every year, folks. We also have the ever-present and self-explanatory Change.org Shut the Judge Rotenberg Center Down petition. Now, folks, trigger warning, when we talk about the JRC, you're going to hear vivid descriptions of and catch clips or surveillance footage of peoples with disabilities being tortured and abused. If you got young children present, please use your headphones, all right? All right, folks. Now, it is 3:18 a.m., stupid o'clock in the morning, and I'm freaking sweating like a freaking pig in a sauna here. I might turn into bacon, who knows? So if I stumble over any of my words this morning, my apologize in advance, all right? Okay, we're going back to where we left off yesterday. Don't forget your calming tea. Here comes the stupid. Conclusions regarding BRI's denial of access to relevant documents and non-cooperation or obstruction with investigation. Oh, do tell. A number of records as aforementioned were incomplete or inaccurate in violation of 104 CMR 30.12. 1, which states, client records maintained by providers shall contain client information which is accurate, complete, timely, and pertinent and relevant to the client's needs and services. Tell me at least they were freaking sanctioned if you can do nothing else to these people. It seems to me they get around court orders, they interfere with police investigations, yet somehow they skate on and continue to stay open. I don't get it. The instance of lack of recording of physician-ordered treatments for Vi on December the 18th is in violation of 104 CMR 20.54, which states, upon instruction by a physician, each client's program record shall document physician-ordered treatments. BRI's failure to provide or delay access by investigations to relevant documents and records violates 104 CMR 20.11c, which states, the head of the program or a designee shall provide, as necessary, appropriate access to a client's record by persons authorized by the department to monitor the quality services offered to the individual, including the Human Rights Committee. 115 CMR 9.083, which states, as part of the investigation, the investigator shall review and shall have the right to obtain copies thereof, all pertinent documents, including but not limited to medical or clinical recordings pertaining to any injury if obtainable, any incident report filed pursuant to 115 CMR 9.15c, relevant portions of the case records of any individual served and involved in the allegation, any relevant policies, procedures, or guidelines of the department and the provider involved or employer of the person complained of. Any other document deemed appropriate by the investigator, if obtainable. Providers shall make all records available to the investigator. Emphasis added. Condensing and destruction of therapy note by a third person violates 115 CMAR 9.162, which provides the staff person observing the incident must complete a written report of the incident within 2 hours of its occurrence and file with the service coordinators assigned to the involved individuals. Failure to retain numerous client records of VI enumerated above, e.g., daily tally sheets, nursing notes, body check sheets, etc., 1990, violates the standard mastered service agreement department has with providers. Let's see here. Yeah, that's Section 7D provides that all records shall be kept for a period of 6 years. The purpose of such retention is to allow for inspection and review of client records, must be conducted in accordance with the sections 5 and 7 for the following purposes: to assure that the services are being provided as specified in the service contract, to evaluate the quality and effectiveness of those services, to monitor the maintenance of such files, and to comply with service delivery standards. All things which the JRC does not do, and they don't want them to get a hold of those records. Who's surprised? What I'm more surprised about is they keep getting away with it. They are allowed to freaking interfere in a police investigation. They are allowed to keep documents that are supposed to be handed over, especially in regards to someone's death. They keep getting away with these things. No wonder they think they're above the law, because Massachusetts has allowed them to be above the law, even when they are complicit in the death of 6 of their students. No wonder they think that nobody can touch them. It's disgusting. Moving on. The general failure by the BRI to either provide or retain relevant documents violates the aforementioned purposes B through E of the Master Agreement, as well as the purpose of Department of Regulations pertaining to records, which is to provide a basis for accountability in the provisions of services 104 CMR 20.312, to meet the legitimate service needs of the client and the documentation needs of the department. Failure of PC2 to answer legitimate, relevant questions during the interview, as aforementioned, constitutes obstruction and non-cooperation with the investigation in violation of 104 CMR. Yet you all keep letting them get away with it and remain in operation, because the court continues to protect them no matter what laws they break. The courts keep protecting them. Make it make sense. Other findings. To determine whether there was any research in the efficiency of or risks of ammonia capsules as used by BRI, the research departments of OSHA and NOSH were contacted, as well as several manufacturing companies of ammonia inhalants, i.e. Burrow Wellcome, Eli Lilly, Consolidated Midland Corp., Newton Laboratories, and James Alexander Corp. All concluded that they have never conducted studies of ammonia inhalants. BRI uses ammonia inhalants manufactured by James Alexander Corporation. The president of the corporation, Francis C.F. Davison, was contacted and asked if testing had ever been conducted for the purpose of side effects regarding the inhalants. Ms. Davidson's reply was negative, and she forwarded a letter to this investigator. Excerpts of the letter included: the inhalants are intended to be used solely to treat or prevent fainting. This particular product has no other medicinal or therapeutic value. We consider the alternative use of this product, the control the behavior of, sorry folks, this is 1995, they were still using retarded, we'll say the other word, intellectual disabilities, by exposing them to pungent odor of ammonia inhalant to be totally inappropriate. Issues observed during a site visit to the residence were the following. We'll get into that tomorrow, folks. We're going to go ahead and close out because that was rather loaded. So what are we noticing here? We are noticing that the JRC has violated the laws put in place to protect students, to protect patients in the state of Massachusetts, time and time and time again. Not only have they violated those laws, but they have also continuously violated investigator rights to have access to records, especially in regards to student deaths and student incidents that have gone viral. The question is, why are they not getting punished? Where are the consequences? Why are they continued to be allowed to operate when at the very least their incompetence, if you don't want to accept anything else, at least accept their massive incompetence, have led to the death of 6 people? If you will accept nothing else except that. Their negligence, their inexperience, the poor training of the staff, if nothing else you want to admit to, has led to the death of 6 people. They have continued to break the laws on those laws that are supposed to protect patients in the state of Massachusetts, and continue to break laws in regards to impeding a police investigation into the deaths time and time again. But they are still allowed to continue to operate. They are still protected, even now, while we are talking. How the DC court did not do the due diligence that I myself, someone who is not a judge nor a lawyer, is doing right here on this channel is completely insane. This place should have been raided and shut down a long damn time ago. They do not meet state standards in standard care, in food sanitation and safety. Their staff is completely undertrained. The list goes on and on and on, but the courts continue to protect them. Why? And on that note, folks, I'm going to go ahead and close out for this morning. We don't get very many views on this channel, especially on this topic. The few that we do tend to get removed from time to time. So, folks, please don't forget to hit that like button. Hit subscribe. Don't forget to hit the comments. I do appreciate your time this morning. And as always, we here at Spilling Tea hope you have a good one. Bye-bye.